on TCI. I don't know how I would ever find time to send him anything. If we could find his telephone number, I might be able to get a chance to call him up.
So everybody, now you know everything that's gone on with TCI. They're totally up to date here on February the 8th, 1996 at 2:06 p.m. Remaining what to do this weekend to get out the logs, add up the hours, add up the dollars, add up the paginate, and get the log out. And I think that I will start right away writing my appellant's brief for the Second Circuit. I'm not going to wait for the scheduling order. I know what it will say. And so I'll just start working on that and try to get that out in the next few days. And that's Glendora versus John Malone, Robert Magnus, TCI, Clouston, Marshall, all the directors, the board of directors, Gallivan and Nafee and O'Brien and Fisher and Kim Magnus, and the Brian Sullivan up in Albany, and the TCI people here in Westchester, Megarelli and Wicker and Rich and Dunn. And that's what happened between February the 1st, a week ago today, and February the 8th, 1996. Humpty Dumpty sat on a wall. Humpty Dumpty had a great fall. Said the lawyer, the bricks in the wall were loose. We've got a good case, so we'll sue Mother Goose. If you have the law on your side, you hammer the law. If you have the facts on your side, you hammer the facts. And if you don't have either on your side, you hammer the table. How can a lawyer write a document of 5,000 words and call it a brief? And George asked Bill, how much money do you have in your bank? And Bill says, I don't know, I haven't shaken it lately. Chat with Glendora. Now on these reports, these fights for rights, of course, one of the biggest areas are neighbors, law-breaking neighbors who violate your rights. And that's the case with Glendora versus Waltel, Pucci, and Larkin. This case has been slowly won. And folks, I believe I intimated to you that I didn't ever think that Bendish would file a respondent's brief in the Appellate Division, 2nd Department. Well, he hasn't. And his time is up, and he's in default. And you remember, and then I said also, if he ever did file a brief, he would just copy over the shoulder of Wilson Babe. You knew that in school, if you copied something, there were serious consequences. Well, not in the New York State Supreme Court. You can see how demoralized and degenerate the judges there have become because Bruce Bendish copied word for word the motion to dismiss of Wilson Babe, Koza, Cousins, Conboy, McGrath, Odell, and Karamitzos, and Judge Ingrassia did nothing about it. So you can see there are no standards over there in the New York Supreme Court. So that's really about the only news there. We have here the outrageous letter from the DHCR, an unbelievably bad job. I thought they were bad enough when I took him before Coppola, and I thought he was bad enough. But this is terrible what the DHCR has come up with, and I don't have time right now to contest it. I will, certainly. But I have too much to do on these other lawbreakers, Cablevision, Continental, and TCI. Let's see. It's a big job every time there's a storm, and we've had 13 snowstorms this winter to clean out the parking space. That should be cleaned out by the landlord, but our landlord doesn't exactly do what he gets paid to do. There was no heat in the bathroom radiator nor the southeast bedroom radiator. And we had a cold spell of 6 degrees. The lowest it went was 6 degrees. We have the sulfur in the cellar, and we have the bookcase in the cellar. And we have Roberta's cigarette butts all over the front walk. And we have nicotine stains on the brand new white enamel washers put there by Roberta. And we had the snowboard, and we had the oilcloth on the laundry room table is all burned black with nicotine fire. Heat yesterday morning at 5 a.m. and Franklin called the Porzio answering service and told him. There was no heat all day long, and then at 3:30, in addition to all that, there was no hot water. The water that came out of the faucet was ice cold. Ice cold. Now, this is the 33rd time that this furnace is broken down, and we have to pay every month $28 for that furnace. That furnace was put in there before we moved here, and the crooked DHCR gives the landlord permission to charge every tenant $28 to pay for that new furnace. And here's a man collecting $16,000 a month from this apartment complex. And the tenant has to pay, each tenant has to pay $28 a month for the furnace, which is broken down 33 times. These are things to tell the stupid, dense DHCR, but I don't have time to do them right away. Nor do I have time to work on the new Wall lawsuit, which is going to be against Judges Wood and Ingrassia and Carlucci and Bendish and Wilson Babe, all of those people I told you. And Koza is still a deadbeat. He hasn't paid the $30 that he owes Glendora for the discovery, for the depositions. We're up to mailing number 217, up to exhibit number 91. Tortious acts is 3,216. Nella's sister was blowing the horn and breaking 4 laws, harassment, White Plains noise ordinance, intentional infliction of emotional disturbance, and abusive. And Daniel Walsh did the same thing, blowing the horn. Leslie was here all day Tuesday painting the hall, and it looks just lovely, the front hall. And I kept making it easier for him by giving him ice water and giving him candy. And I let him borrow my ladder. The wall file is all up to date. It's 3,869 pages of bad record. That's close to 4,000. They're on volume 34. And it's all on hold right now until these fights are won with Cablevision, Continental Cablevision, and John Malone, Robert Magnus, and TCI. A week, if not twice a week, I check the Appellate Division, 2nd Department in Brooklyn. It's part of the New York State Supreme Court, and here's the report for today.
Chance of that.
Okay, let me just see if there's any motions outstanding.
No, he didn't make a motion. He wrote a letter.
You wrote a letter?
Yeah, it's an epic. He didn't do anything but write a letter. He didn't make a motion.
Just bear with me 1 second. See if I can...
Yeah, take your time. I appreciate what you do for me.
Appellant's request for new date.
No.
Oral argument miscalendar date denied by Judge Sullivan, it says, on January 9th.
Oh, wait just a second. Thanks. Denied by Judge Sullivan
Right.
on January 9th. So that's over with.
Yeah.
Now, is there a decision on the oral argument of January 5th?
That'll be coming down shortly. I suggest you call back next week.
That's okay, Robert James Shortly. Call next week. Yes, the next number is Glendora versus Hubbard. I'll write down that number.
That's 949045.
9045 Hubbard. Did respondent submit a brief?
No, I don't see anything after you mailed in some assorted documents. arguments on June 26th. I don't see anything at all from the other side.
Thanks. Is it
Your record and brief.
Thank you very much, Robert James. Is it calendared?
Let's see. Not yet. I'm working on it, so it shouldn't be too much longer.
It's okay.
All right.
Yeah, now, Robert James, we have Glendora versus Daniel Walsh. There's two of them. Supreme Court split the case. So the first one, 95.
3831?
Yes.
Okay. I see everything is filed on that. And that's not being worked on yet, so it's a while. That was only filed in October.
Yeah, that'll be a long time. Okay, now I want to know on the second one if the respondent submitted a brief.
Not yet.
Okay, so that would be 95...
6359.
Repeat, Robert?
95, 63, 59.
63, 59, and no respondent's brief.
Not yet.
Thanks for the information. I'll tell you today's joke.
Which is?
Peter bought a used car, and he wondered how old it was. And he didn't know, but he knows that the speedometer is in Roman numerals. Say hi to everybody, will you?
All right.
Thank you, Robert James.
Right.
Bye-bye.
You know.
10:08 a.m. Appellate Division. That's the scorecard for 1996, February 8th. Robert Callaghy, please. Mr. Callaghy is not in. May I take a message? Yeah, would you give him a... Yes, please. Certainly. Here's a letter to the Appellate Division, Second Department. He missed the oral argument. Which letter? I'm sure he's written many. Okay. He missed the oral argument. On what case? Glendora versus Kofalt. When was the oral argument? January 5th. Okay. Glendora versus Kofalt. K-O, F as in Frank, A-L, T as in Tom. Okay. He missed the oral argument through malpractice, and then he asked for another oral argument, and that's just hopeless. The Appellate Division doesn't do that, and it was denied on January 18th. Okay, I'm going to pay. He's in trial for the week. Okay, where's that down? The New York Supreme Court? I have no idea.
Well, it is. I saw him there Monday.
I will pass this on to his secretary this morning. Okay, and who am I speaking with? Oh, this is Glendora. Oh. This is Glendora, who beat him on 4 cases. Wonderful. I got a joke for you when we finish. To tell you the truth, Glendora, I've got more important things to get to. I'm sorry. Oh, no sense of humor. Well, I wouldn't expect after working at Satterley. Take care.
Satterley, Stevens, Burke and Burke. Now we're going to report to you on Cablevision from February 1st to February the 8th, 1990.
The time of that call is 10:10 a.m. a magic minute. Thank you, God, for this beautiful day.
10:10 is a
for life
magic minute.
And for the operation
11:11,
of your great
12:12.
universe. Amen.
The Callaghy letter came in, and it's really dishwater. It's really not much else. I'll come over there and show it to you. As too far as his opposing, my deposing, Charles Dolan, John Tata, and Philip Sweet. And so it was really nothing, but on Thursday morning I wrote out my opposition to give orally to the Judge Fox Court, and I was scheduled to be there at 9:45 and that's Jerome Great's court, and I will play you the audio tape from that court on Groundhog Day.
This man was scheduled for 9:15 for a third of fourth time, one counsel or the other is not present. This matter was last on the 18th of December. Have the depositions been completed, the expert depositions?
I believe so, Your Honor.
Okay, just identify yourself for the record, please.
My name is Richard Mandaro, the defendant, from the office of Conley, Lario, California.
Okay, the record should reflect plaintiff's counsel is not present. I take it that all discovery is done?
That's correct.
Okay. The matter was adjourned to this morning with party representatives with settlement authorization to be present or immediately available by telephone. Since plaintiff and his client are not present, I'll ask defendant, do you have someone available by phone or present?
Yes, I do. I have authority at this time.
Okay. Have you communicated it to plaintiff's counsel?
I haven't directly communicated during discussions with my office, yes. We were hoping to come to some.
I hope so too, but if they're not interested in being here to settle it, we've got a trial date. The case is scheduled to be tried on the 15th of April.
Correct.
Let me see up at the sidebar, please, off the record.
You have to sidebar because you didn't want you to hear. Still more trying to deal with the counsel that's present, but he doesn't want the public to know. So let me get the title for you. Glendora versus Cablevision.
This matter was last on the 18th of January. And it was adjourned until this morning. The only remaining issue had to do with the additional requests for discovery. I have received correspondence from the plaintiff requesting to depose James Picken, Bertram Patterson, Philip Sweet, Charles Dolan, James Kofalt, and John Tata. I've also received an answering letter from Mr. Callaghy. That correspondence with the plaintiff, Glendora, was all dated January 25th. There was a response dated January 31st from Robert Callaghy opposing that discovery. Is there anything that either side wants to tell me in reference to any of these depositions that is not set forth in the correspondence?
Yes, Your Honor, I have an oral answer.
Go ahead, please.
Thank you. To deny depositions of Mr. Picken and Mr. Patterson and Mr. Sweet, Mr. Dolan, Mr. Kofalt, Mr. Tyler would be unjust. If the court is here for justice and the truth must be told, this court in all conscience cannot allow these defendants and non-defendants not to be deposed. This court has damaged the cause of truth and justice enough by allowing Mr. Callaghy, Dolan, Tyler, Quinn, Osnara, and Formeyer et al. From answering from Memorial Day 1995 to now without telling the truth. And why should this court be solicitous of these convicted lawbreakers and tolerate their 50 violations of Federal Rules of Civil Procedure 26 to 37? Defendants were coerced by a governmental person to take Glendora's program off TV, and it looks like that governmental person was James Picken, who with Galata did not want the public to know his bad but true record. This is the only reason that makes sense. You have read the testimony of Osnara and Garger, and Quinn is coming, and you can see that they're contrived reasons of not a resident of Nassau and the sponsor not a resident of Nassau make no sense. This is hardly a defense. Judge Bryan already adjudicated July 19, 1995 that Glendora's residency had no bearing and that her sponsor was correct.
Stevens as justice and truth. Cablevision, Dolan, Todd, Kelly have no evidence to the contrary. Plaintiff has not had her full and complete discovery, let alone full and complete depositions, because defendants have lied and covered up and insufficiently responded to discovery made in February. They have not answered interrogatories, they have not produced documents, they have not faced admissions, and they have fled from inspections. Yours in truth, Glendora.
Anything further?
Yes, Your Honor, thank you. Your Honor, I would like to make an application.
Anything further with reference to these depositions, I'm asking?
Well, let me ask you first. That Mr. Gerfine from Sadler, Stevens, Burke & Burke tell you that you ordered him to tell me right now who their insurance company is. I have asked for that since May. Who is their insurance company? That's basic discovery.
I'm asking you about these depositions. Is there anything further you want to bring to my attention with reference? Anything further you want to bring to my attention with reference to your request for those 6 depositions?
Okay, Your Honor, I heard you, but when do I get...
Right now we're going to deal with this issue. Is there anything further that you want to argue or that you want to bring to my attention about your request for these 6 depositions?
Yes, and when do I bring...
Tell me what it is, please.
Excuse me?
Tell me what it is, please.
About the deposition?
Yes.
Okay, but when do I bring these other points?
Now look, I've already told you twice I'm going to deal with this issue first.
Yeah.
Is there anything further you want to tell me about these 6 depositions? Yes or no?
I've only asked you 3 times. When do I deal with these other matters?
You can be seated. You want to be heard on this?
Nothing is not in the letter.
All right, fine. With reference to these 3 depositions, the 3 Dolan, Kofalt, and Tata, Mr. Dolan's deposition or the request to depose Mr. Dolan had previously been denied by Judge Bryant. I had previously denied the plaintiff's applications to depose Kofalt and Tata. The plaintiff is also requesting again, or I think for the first time, to depose Picken, Patterson, and Sweet. Based upon the letter briefs that have been submitted and the arguments which I have considered, it does not appear to me that any showing has been made that these depositions would be reasonably calculated to lead to the discovery of relevant and or admissible evidence. And under those circumstances, since there has been no showing made, the application to depose these 6 witnesses, 3 having been previously denied or denied again, the other 3, Picken, Patterson, Sweet, are also denied. Now, with reference to
I'd just like to know.
request for insurance, was that request made in any interrogatory that was previously served?
Yes, May 30th, Memorial Day, 1995.
Have you answered it?
I don't know whether that's accurate or not.
Is the claim in this case covered by insurance?
Your Honor, I do not know.
Well, it seems to me if there was an outstanding interrogatory, your obligation is either to answer it or to file an objection.
I would agree with that, but I just don't know as I stand here today whether that request has been made and if so, how it's been responded to.
Says it has, and it has not been objected to. The defendant is directed to respond in writing by 5 p.m. Monday, February the 5th. The question, of course, would be whether there's insurance coverage regarding the claims being made by the plaintiff in this action. Right. All right. Is there anything else that we need to talk about on this matter?
Yes, Your Honor.
What does that be?
I would like to note that that decision was made before you heard my argument. Your decision to not let me depose those 6 people.
You have the court's decision on the matter. I heard your argument. You have the court's decision on the matter.
No, you didn't hear my argument.
Next issue, please.
You did not hear my argument, and I want to go on record as saying so. Your Honor, did you sign my informant papers?
That application I am not entertaining. You can bring that application to the assigned district judge.
But the assigned
Since
district...
discovery is complete, since discovery is now, in my view, completed on this matter, that is something that you should bring to the attention of the judge who's going to try the case. I'm not entertaining the application.
But the judge said that Judge Fox is in charge of that, and two judges cannot be in charge of case management.
What's the next issue?
Well, I still have things to say, but I said, all right, I'm not talking about depositions. I'm talking about discovery. How can discovery be complete when these people haven't done interrogatory documents, inspections, and admissions? All my discovery demands have been filed with the court. The court should be well aware of them.
As has been pointed out in previous arguments that she's made in connection with that particular issue, it's my understanding that Judge Bryant had ruled on all previous objections with reference to written discovery. You now have rulings with reference to all the depositions, and I'm making the determination that discovery is complete, and Judge Bryant's chambers will contact both parties with reference to a trial date.
Okay, I have more things. I want to say that defendants have no defense and never have had. I have an application here that the matter that I am trying to prove that they acted under color of state, that they acted under pressure of some Nassau County political or Suffolk County political, I would like to ask that that matter be deemed admitted for purposes of litigation on the grounds of their discovery default.
Your application is denied.
Yet. I applied that
that was
the court
subject to
order
an order. That was an order that was addressed to Judge Bryant. It is not before me.
Well, I think it is by what Judge Bryant tells me. Or told me the last time, December 11th.
I want you to understand something, Glendora. I'm not going to argue with you. You make applications and I give you the decision. If you're not happy with the decision, you have a right to file objections and appeals, as you well know.
Yeah, I want to go on record right now as taking exception to all of your rulings this morning.
That's fine. You have a right to do that.
And I think they are appealable. Cablevision hasn't settled. They haven't tried to settle. And I think that's a rule. In the local rules, I think that's a rule. I would like to ask you, will you examine Mr. Colfault by telephone from Virginia?
Your application is denied. I've already told you you're not going to depose Mr. Colfault.
You want to know who the decision maker is, don't you?
Do you have any further matters to bring to my attention?
Look, Judge Fox, I find it very difficult to present justice and truth before you. Now, I want to make an application that Cablevision pay for the minutes, for the Gardner minutes, rather, because Mr. County ordered the defendant 80 times not to answer.
Denied.
And I have cases for that. Schreier versus Ford and Fox versus Studebaker and Henry versus Snyder's. Other people who could have made this decision were Mr. Dolan's sons during Mr. Dolan's long absences, his son James or his son Patrick. Rule 37A, inadequate response. Misconduct, which consists of an inadequate response to a discovery request application. Are you going to let that go?
The record should be plain that when you were here on the 18th of January, I directed that any further discovery issues be raised in two-page letter briefs before me, returnable before today. I've entertained the letter briefs that have been submitted. Any other discovery requests are denied. I'm certifying discovery as being completed in this matter, and I'm directing a return to the district judge. The matter is adjourned.
Thank you, Judge. Object.
Noted.
All rise. Recess. Calling Mullane versus Roundabout.
Okay. I've had a conference in chambers with counsel, and I'm now advised that the parties have arrived at an understanding in this matter, and counsel, please put it on the record.
Yes, Your Honor. Your Honor, after the indulgence of the court and numerous conferences and...
Excuse me, Mr. Kitson, why don't you just note your appearance against the record is clear?
Here is something, folks. Mr. William Quinn, whom you know, I deposed on January 18th. Right after that, I sent him and everybody else my report on his deposition. And I get this back, and it says that he's no longer at this address or address unknown. And this is phony, and Franklin has said so, and we're going to send this to the postmaster of Buntontown. It says mail has been sent to this address for 2 years and 2 months, and this is the first to be returned. Prior to all these mailings, I was at this address to serve legal papers on Mr. Quinn, and that's Franklin F. Buell. The log did go out, folks, the Glendora TV log. It was processed and it was mailed on Tuesday. And this is the new log that started up Monday. And I got all of the cable vision work up to date. Do you believe it? Now, I don't mean the old cable vision work that I had to give up on 3 months ago because of pressures to do the depositions and all these other things. The 8 jobs that I used to do every day. That hasn't been touched for 3 months. But the current stuff, I did it all, and I got it all up to date. And that hasn't happened for a long time. And here is a letter from Glendora to Judges Bryant and Fox. And Callagy writes, we represent the defendants in the above captioned action. And Glendora says, well, they don't represent them very well. Callagy missed the oral argument of Glendora versus Kofalt at the Appellate Division, 2nd Department on January 5th, 1996 at 6 a.m. Callagy missed the last conference with Judge Fox, February the 2nd, Groundhog Day. And Gerfine was there, and he kept saying, I don't know, I don't know, I don't know. Callagy missed the Quinn deposition of January 18, 1996, 10 a.m. to 12:20 p.m. Callagy postponed the January 10th Quinn deposition. He postponed the January 16th Quinn deposition. So he is really not representing them very well. Has Cablevision stopped paying Callagy? That's a good question, isn't it, folks? Is that why he doesn't show up now? On December 30th, 1995, plaintiff filed an IFP affidavit with its court in which she declared under penalty of perjury that she owns no cash and has no money in a checking or savings account. However, in the same affidavit, she did reveal that she had earned interest on money in bank accounts for the months of January to August 1995 in the sum of $3,000, and that's divided by two people. A copy of this affidavit is enclosed for your reference. Glendora sees no conflict. Callagy is not reasoning deductively or reasoning at all. Glendora wants to see Callagy's affidavit of checking and savings account. He acts informally.